Good day, Crime Talk aficionados. We've got a great show for you today. First, federal prosecutors confirmed that Luigi Mangione, well, he's not going to Pennsylvania. Brian Walsh's murder trial gets delayed for his mental evaluation following his assault in jail. The sister of a murdered victim is charged with harassment. Shocking. A Fulton County judge down in Georgia apparently thinks judicial rules are mere suggestions for lesser mortals. The Supreme Court gives Ghislaine Maxwell the cold shoulder on her latest bid for freedom. We've got this day in legal history, our legal quote of the day, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. And I can tell you, we are getting a lot more downloads directly from podcasting sites, specifically Apple. It's amazing. One day, we're doing really good, and then bam, it just went through the roof. So thank you all for watching. Now, before we get to the docket, let me remind you to do a couple of things. First, go to crimetalksearch.com, sign up for that background subscription service. When you do, you're going to get a report on the person that you're searching about, paired while you wait, and then the results are emailed to you, and you're going to get information about their social media presence, email addresses, phone numbers that they use. Why do they have a burner phone? I don't know. They didn't give you that phone number, but yet they still have the phone. Why do they have all those email addresses? Is that for their dating sites that they sign up for, but they don't want it to come to their main email that they give to you? You're going to find out about criminal histories. You're going to find out if they're married. Are they divorced? Do they have liens and judgments against them? You name it. You're going to find out. You're going to find out more information that you probably want to know, but you probably need to know. So go to crimetalksearch.com, sign up today. You're going to be happy that you did. Also, quick reminder, go to the link below. You can get the cool Crime Talk merchandise, like these keychains and bag tags. Took these to Italy with me, put them in my backpack, so I knew exactly what was there. And of course, you can get the Baked in Colorado dog treats there as well. Hey, if you love your dog, you're going to give them CBD treats and make them feel like $1 million. All the healthy stuff, none of the stuff that's going to make you high. And then, of course, we've got some new shirts as well with more to come. So go check out the link below. Got to get your Crime Talk merch, man. You got to get it. All right, let's go ahead and open the record for Tuesday, October 7th, 2025. Yep, the federal prosecutors are saying, yeah, we're not giving up Luigi. And I'll explain in greater detail why that is done and what it means. All right. So federal authorities have formally notified the court that Luigi Mangione, charged obviously with the murder of the United Healthcare CEO Brian Thompson, will not return to Blair County, Pennsylvania to address separate charges stemming from his arrest at the local McDonald's. Now, recent filings in the case from the United States Attorney's Office for the Southern District of New York indicate that Mangione will stay under federal custody rather than being extradited back to Blair County. Now, though an earlier email from the office had conveyed this position, Mangione's Blair County Defense Counsel, a guy by the name of Thomas Dickey, insisted on official documentation. Now, this development resulted in the postponement of Mangione's scheduled hearing in Blair County as he declined to participate remotely. Dickey argued that his client's constitutional entitlement to be in person must be upheld. And frankly, I agree with that position. It's a critical stage of the proceeding. You got to have the defendant there. Now, the prosecutors have stated that such a transfer is frankly impractical, citing the significant logistical challenges and expenses incurred during Mangione's initial relocation from Blair County to New York, which were exacerbated by extensive media attention. At present, Dickey's subsequent actions remain unclear, though it appears Mangione will not be present at any hearing. So nothing's going to take place. So this gets a little interesting, all right? Although Mangione was originally arrested in Pennsylvania, he was in state custody. Then the feds got him, all right? And then he was transferred to New York because he's got the state murder case and the federal murder case. And so ultimately now he's in primary federal custody. The feds like to keep their prisoners tight and nestled in, because their concern is that they send them back to the states, somehow they get released, and it creates lots of problems. So the the Fed is like, we're going to keep them. The states can do what they refer to as an 11-point memorandum, requesting that somebody basically appear on a writ or in person to appear in state court. And then they're sent right back to the federal custody. Feds don't like to do that. Okay. And once the feds get you, that's it. Now, what really gets complicated is when you're originally being held in the state, feds got a case, feds keep you, you get sentenced in the feds, you get sentenced to the state, they send you back to the state, you serve your state sentence, and then you go do your federal sentence. It gets real confusing. It's called primary federal custody and primary state custody, and it really is a battle of the sovereigns, so to speak, as to who gets you and who gets first. And particularly if there's like concurrent sentences, like the feds don't really recognize, we're going to make your sentence concurrent with the state case. They don't do that. State's a little easier, but you still got to go serve the Fed time. Then they ship it back to the states. Then they calculate everything, but it gets really confusing and messy. But here's where things get interesting. Now, remember, they entered a plea of not guilty in the Mangione case, is my recollection and understanding. So speedy trials should be ticking. And I'm not aware of any waivers, but if there are, that's okay too. But if there's not any waivers, the case could get dismissed in Pennsylvania. So the prosecutors may have to do it because of speedy trial issues. The defense could say, no, we demand you be brought in. If state can't prosecute it, dismiss the case. So it could work out well for Luigi Mangione in this particular case. Now, the state could always dismiss, refile if there is not a sufficient enough sentence in the federal case in New York or the state case in New York to satisfy them. But frankly, it's the least of his concerns. It's having some forged documents, the gun, whatever. That's all going to be taken into account at the federal sentencing if he is ultimately convicted, which he's entitled to the presumption of innocence. So this could work out for Luigi Mangione, but the reality of it is, once again, I hate to say it, but we got to wait and see. But I think that's the play that his attorneys should be doing in the future, having the state demand that the state dismiss in Pennsylvania. Next on the docket, Brian Walshe. Do you remember this guy accused of killing his wife, chopping her up, disposing of the body? Well, in an ironic twist, the trial of Brian Walshe, accused of murdering and dismembering his wife, Anna Walshe, has been postponed to assess his mental competency after he suffered some trauma from a stabbing incident that was in the jail there, perhaps offering him a belated glimpse into the horrors he allegedly inflicted upon his wife. Now, originally, trial was set to commence on October 20th, with the proceedings against Walshe for the alleged slaying of his 39-year-old realtor spouse on New Year's Day in 2023 have been delayed. Anna Walsh's body remains undiscovered, adding to the grim narrative surrounding the case. So on Monday, the Norfolk County Judge, Diane Frenier, approved a defense motion to transfer Walshe to Bridgewater State Hospital for a 20-day psychological evaluation, as documented in court records. Now, Walsh's attorney, Larry Timpton, asserted that his client's mental and physical state has deteriorated due to the assault last month, rendering him incapable of effectively contributing to his defense preparations. Now, Timpton noted in the filing that despite Walsh's effort, the lingering effects of the unexplained and sudden attack have severely hampered his ability to collaborate with counsel as the intricate trial nears. Now, prosecutors opposed the continuance, arguing that no substantial evidence indicated mental incompetence and pointing out Walsh's prompt return to jail on the day of the incident. Now, a competency hearing is scheduled for October 27th with no new trial date yet established. Now, Walshe is a resident of Cohasset and has entered a not guilty plea to the charges, including first-degree murder, obstructing an investigation, and concealing a corpse. Anna was the mother of their 3 children. Now, surveillance footage captured Walshe purchasing various items around Home Depot, such as, the normal stuff, mops, brushes, protective eyewear, and a utility knife, which authorities allege were employed in disposing and chopping up Anna's remains. Investigators reportedly recovered a hacksaw containing a bone fragment from a dumpster near Walsh's mother's residence. Additionally, Walsh is accused of using his son's iPad to research body disposal methods online and engaging a private investigator to probe suspicions of Anna's infidelity prior to her disappearance and dismemberment, allegedly. Listen, you got to take the attorney at their word, okay? But normally you file a motion for competency when really your client is not there. The mental capacity is not there, okay? Find out your client's schizophrenic. Maybe he's got early onset dementia, all types of things that, you deal with, usually a long history of mental health issues. And then they're sent off, they're evaluated, and then the competency report comes back. And usually it comes back that the person is competent to proceed. It's a very low standard. Who are the parties in the courtroom? What are their roles? Do you understand the charges against you and basically the process? That's it. But sometimes there's a kind of a catch-all where there's something just not right here, right? The guy can't assist in his preparation. And usually there's a history of mental health issues. In this case, Walsh's case, I find it hard to believe. It seems like a delay tactic to me. My guess is, and it's speculation, but I think I'm going to be right, that he's going to come back and he's going to be just fine, okay? This man is accused of killing and dismembering his wife, whose remains have never been found, the mother of his 3 children. He gets attacked and stabbed in prison, and suddenly now that trauma has made it so that he can't assist his attorneys in the preparation of his defense? Please. And in all honesty, this case has been going on for years. At this point, let's face it, the guy's probably not going to testify. What really role does he need to participate in? Yes, you got to have a competent client. I get that. But let's get for real. The reality, the stress of probably spending the rest of your life in prison is coming to fruition. And all of a sudden, he's getting a little freaked out. There's no reason for delay, no further reason. But if I get a competency evaluation, maybe this will, delay something. Maybe something bad will happen to a potential witness. Evidence will get destroyed. The games that oftentimes people play, ladies and gentlemen. And I think, we'll give this attorney, we'll assume that he is acting in good faith in filing the motion. All right. But my guess is he's going to be just fine. Just fine. Next, a sister of a murder victim gets arrested for harassment. So, how utterly brilliant. Teresa Clark, the sister of the vanished Texas mother, Suzanne Simpson, has decided to play vigilante and now finds herself slapped with criminal harassment charges for her oh-so-helpful crusade against the family of her brother-in-law, Brad Simpson, the very man accused of murdering her sibling. Because clearly nothing says justice for Suzanne quite like bombarding Brad's relatives with late-night phone tirades and a relentless social media blitz, complete with gems like, "You don't know who you're messing with, and you will not get away with this." Police, in their infinite wisdom, have deemed this a vigorous media campaign, but let's be real, it's just a fast track to her own legal headache. Now, one might think that with Brad already indicted for murders and Suzanne's disappearance back on October 6th of 2024, after that charming domestic spat at their Olmos Park residence, Teresa could have sat back and let the wheels of justice grind away. After all, Brad's rotting in custody on a $3 million bond, with his adult kids cutting ties and strict no contact rules with the younger one who allegedly saw the whole mess unfold. But no. Why trust the system when you can torpedo your own credibility and rack up charges that do absolutely zilch to bring Susan back or strengthen the case against him? Truly a masterclass in self-sabotage. You see this all the time. I get it. Victims, you're upset. You're angry. Harassing the defendant's family. Showing up to court, mean mugging the defendant, acting like you're going to be a tough guy in court. That's all ridiculous. It's stupid. Let the process do its thing. Otherwise, you have to you got to respect the process. Otherwise, you are just going to look like some basic street thug that more than likely they're trying to get off the street, i.e., her brother-in-law, who allegedly, once again, killed his wife and tried to make her disappear the body. I mean, those types of things, ladies and gentlemen, let the system work. You got to have some trust in the system. I know it's hard sometimes. It's frustrating sometimes, but normally the way things work out are the way that they're supposed to work out. So you got to trust it. Next on the docket, a judge thinks judicial rules are, suggestions for lesser mortals. So, in a stunning display of judicial humility, a state panel has graciously suggested that Fulton County Superior Court Judge Shermella Williams might want to consider stepping down from her exalted position. After all, who needs bothersome things like truthfulness or legal protocols when one is so clearly above such trivialities? So the Judicial Qualifications Commission's 3-judge panel, in their infinite patience, has leveled over 30 accusations of misconduct against Judge Williams, spanning years of what appears to be a masterful interpretation of the rules as among, optional guidelines. Among the highlights, fabricating testimony under oath, because evidentially perjury is just a quaint tradition for others. A judge who cannot be trusted to tell the truth cannot be trusted to remain in office, after all. That's what the panel noted as well, as if stating the obvious for someone who might have missed the memo on basic integrity of judges. One can only imagine the surprise when the panel uncovered delays in rulings that stretched into years. That's right, 29 months in one case, no less, despite Williams' valiant efforts to manage her caseload. And during a hearing, a fellow judge politely inquired, "How is it anyone's fault but yours?" To which Williams responded with characteristic transparency, "That's not what I'm saying." How enlightening. But wait, there's more elegance in her approach. The panel discovered improper ex parte discussions with a sorority sister involved in a case, because sisterhood apparently trumps impartiality, and assistance extended to a family member in another matter. As any credible attorney would note, judges not only have to do the right thing, they have to avoid even the appearance of impropriety. Now, oftentimes attorneys will say that judges like this, tried their best to get it right and might not have intended wrongdoing. I don't know. Does that reassure you at all? I don't know. The crowning achievement, however, must be the incident where Williams, the judge, in a fit of innovative jurisprudence, ordered a 21-year-old witness testifying for her mother into custody mid-hearing. After incessant interruptions, she commanded a deputy to show her what that cell looks like, framing it as a scared straight tactic. Williams later admitted to the panel that was not the right decision, as if such an epiphany required external prompting. Now, some people, trying to be diplomatic, will say that you've seen it all, right? And then you see something like that. Yeah. Anyway, throughout these proceedings, the commission observed that Williams' testimony evolved with remarkable fluidity, suggesting a flexible relationship with the facts. The panel deemed these lapses the antithesis of judicial conduct, had little opinion but to seek the ultimate sanction of removal. And yes, ladies and gentlemen, when the panel is telling that you are loose with the facts and these and your recollection is very fluid, that's a nice way of saying, Judge, you're a liar. And we can't have judges that are liars doing that. They're supposed to be fair and impartial. They're supposed to be doing it better than everybody else because they are the ones enforcing the law. I don't care if you're a police officer, you're a prosecutor, you're a defense attorney, you're an officer of the court. You have to be doing it better than everybody else because you're held to a different standard. You really, truly are. Next, the Supreme Court gives Ghislaine Maxwell the cold shoulder. Well, isn't this just shocking? The illustrious United States Supreme Court has decided to pass on reviewing the appeal from Ghislaine Maxwell, the paragon of virtue convicted for luring underage girls into a web of exploitation. Now, according to the court's oh-so-predictable order list dropped on Monday, they perfectly they are perfectly content letting the Second Circuit's decision stand tall. Now, Maxwell, the spry 63-year-old ex-paramour of the notorious child predator Jeffrey Epstein, got slapped with convictions on 5 counts, including trafficking of minors and related schemes, earning her a cozy 20-year stint behind bars. Now, of course, she recently traded her high-security digs in Florida for a more relaxing work camp in Texas right after spilling the beans for 2 full days to Deputy United States Attorney General Todd Blanche, assuring him that President Donald J. Trump was an absolute angel during his alleged encounters with Epstein, only at his residence, Mar-a-Lago, not on any plane trips or not on any Epstein Islands, anything like that, and that he was quite the gentleman. Now, ever since her guilty verdict, Maxwell has been on a tireless quest to either ditch the conviction entirely or snag a presidential pardon because, hey, why not aim high? Her freshest appeal, just arguing that Epstein's infamous 2007 bargain basement plea deal with Alex Acosta back when he was the U.S. attorney in the southern Florida district there, and later Trump's labor secretary, should magically shield her from any consequences. That gentleman of agreement had Epstein copping to minor prostitution charges and signing up as a sex offender, complete with a sneaky clause supposedly protecting any accomplices. However, the appeals court pointed out that it only covered Florida antics, not the New York charges that led to Maxwell's conviction. And now, as for Epstein, he faced a much stiffer federal accusations for abusing minors, but conveniently checked out back in 2019 while awaiting a trial, with authorities deeming it a unliving. Very tidy. Anyway, Maxwell's lawyer, David Marcus, says that they will keep chasing down every possible loophole to ensure justice is served, because clearly that's what this is all about. Ghislaine Maxwell. Remember that? Back in the day, we couldn't even remember that guy named Jeff. We had to hold up a sign. Otherwise, we get demonetized. Oh, how times have changed. And, her original trial counsel were from Colorado. They did a great job. She's going to have to go serve her sentence, and unless she gets some sort of commutation of a sentence or some pardon, she's going to have to go do her time. And remember, in the feds, you serve 85%. So on that 20-year sentence, she's going to do 17 years of that before she is sent out on supervised release, which is a fancy word in the federal system for parole. Next, this day in legal history. On October 7th, 1763, King George III issues the Proclamation of 1763, prohibiting colonial settlements west of the Appalachian Mountains to appease the Native American tribes, a key precursor to revolutionary tensions over land rights and governance. Come on, doesn't the king know? It's all about conquest. That's the way it was back then. To the victor goes the spoils. Anyway, then there was the tax stuff, right? On this date, 1765, the Stamp Act Congress convenes in New York, the first intercolonial meeting to protest British taxation without representation, influencing constitutional arguments on taxation and consent. Remember, tax on tea was 3%, ladies and gentlemen, and people were willing to go and fight a revolutionary war over 3%. Oh, what cowards we have become these days, haven't we? And on this date, October 7th, 1935, the United States Supreme Court convenes for the first time in its new building on 1st Street Northeast in Washington, D.C., symbolizing the judiciary's permanent role in the federal government. And I highly encourage you, if you ever go to D.C., one of my favorite cities to go to, just for all the monuments and the architecture, go to the United States Supreme Court building, see if you can get in, get a tour, to go up into the actual courtroom where arguments are made. I mean, literally, I remember sitting there, second row, literally the distance from about me to Frank right now, about 9 feet. There were all the Supreme Court justices, and the pomp and circumstance. It was amazing. It was everything you thought. This is why I went to law school in my much younger days, to be there for something like that. amazing, amazing building. Next, our legal quote of the day: acts indicate the intention. It's an old legal maxim. And finally, our dumb criminal of the day. In a display of unparalleled brilliance, meet Christopher Everson, our 43-year-old dumb criminal of the day from the Smyrna Beach, Florida area. Now, this mastermind allegedly decided that the best response to a group of kids creating minor waves near his boat on the intercoastal waterway was to pull out a gun and threaten to shoot them, and watching them bleed out, as per the police report from October 4th. Now, the sheer genius. Everson reportedly grew furious over the juvenile's vessels generating a wake in what might have been a no-wake zone, prompting him to wave what appeared to be a semi-automatic handgun, silver and black no less, at the approaching kids en route to the South Causeway. Witnesses captured video evidence showing him reaching into his pocket for the mysterious item, which conveniently matched the shape of a firearm. But wait, Everson's stories adds even more layers of cleverness. When questioned by police, he admitted to a stupid argument with 4 to 10 kids who were supposedly cursing at him and his fiancée aboard the boat. Yet he insisted it was merely a glass case and his keys that he brandished, not a gun. Heavens no! His fiancée backed this up, and he politely declined officers' request to search his home for the firearm he admitted owning. How utterly foolproof. Thanks to quick-thinking bystanders who noted his boat registration and license plate as he trailered it away, police tracked him down. Everson now faces charges of aggravated assault and improper exhibition of a dangerous weapon, earning him a well-deserved stay in the Volusia County Jail. Truly a shining example of how not to handle a ripple on the water. Can you believe that, ladies and gentlemen? A menacing of kids for making a wake in a no-wake zone. Yes, sir. You are our dumb criminal of the day. We'll give you the presumption of innocence, but as those facts read, boy, is that dumb and stupid. Let it go, ladies and gentlemen. How many times have we said to let it go? All right, that's all we have for today. Thanks for watching. We'll see you next time. And remember, the Constitution matters.